Once a court has issued a child custody order, in Nevada, there's a specific law that details what standard you need to meet if you want to ask the court to modify that child custody order. And now modification, it could mean a change from joint physical custody to primary, from primary to joint, or from primary with one parent to another, but it also can include a change in timeshare that is a significant difference in the amount of time that one of the parents has, even if it's not changing the custody designation. Now, in order to have a change in custody, the standard that the court looks at is, has there been a substantial change in circumstances affecting the welfare of the child, and is modification in that child's best interest? And this two-part test, in this, there's the best interest factors, which is a list of factors that the court has to look at when they're making the determination, is modification or is a certain custody in the best interest of the child. And so when you want to go to court to modify custody, the procedure is that you file a motion, you detail out why the facts of your case meet the standard, and that motion gets filed with the court, and they'll set a hearing date on it. Sometimes judges will do it without a hearing date, but once the judge actually reviews the moving papers, which is generally your motion, the other side's opposition, and then a reply brief that you file, they'll decide whether or not they're going to allow the case to move forward to a trial. Now, our appellate courts in Nevada have been very clear that if someone has at least alleged facts that would meet that standard, whether or not the judge believes them, that they have to set an evidentiary hearing in order to make this determination on custody. The district court can't just say, nah, I don't believe this, and deny your motion at that stage if you've alleged things that if they're true, would be sufficient to modify custody. So when you file a motion to modify custody, you want to make sure that your motion has a lot of details to meet that standard in it, enough so that the court will set the evidentiary hearing and actually hear everything you have to say from you, from the other side, from witnesses, look at your evidence, your documents, and make a decision modifying custody.